Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Criminal Justice, PGDCJ. MLE 015 Challenges to Criminal Justice System. Block -1 Legal Aid. Unit-4 Legal Aid in Other Custodial Institutions. 1.1 Introduction. The concept of legal aid has changed due to the change in the idea of social justice. The meaning of social justice simply means imparting just and fair justice to the society without any disparity. The two important elements of social justice are 1. Economic equality and 2. Protecting weaker sections of society. Nowadays, the attitude of the policymakers as well as judiciary is to extend the benefits of state to provide legal aid to the vulnerable classes of persons in custody other than police and prison. They are mainly juvenile custodial institutions, mental asylums and institutions of aged persons. 1.2 Objectives. The student who completed learning this unit should be able to know the areas of legal aid other than police, court and prison. Scope of legal aid in different jurisdictions. Legislations having provisions insisting legal aid to the vulnerable group. The legal aid system in India. 1.3 The right to counsel to mentally ill person. The right to counsel for the mentally ill is the cornerstone of the process of involuntary admission into a psychiatric hospital. If the mentally ill person subject to involuntary confinement is unable to afford an attorney shall be provided by the state. Here it is worthy to discuss a landmark case of the United States Supreme Court in which the court enlarged the right. It was in re Galt, which involved a 15-year-old child committed as a juvenile delinquent to the Arizona State Industrial School for making lewd telephone calls. Justice Abe Fortis, writing for the court, rejected the state's claim that appointment of counsel was discretionary and decreed that the child and his parent must be advised of the juvenile's right to be represented by counsel chosen by them, or if unable to afford counsel, that counsel would be appointed to represent the child. The court was cognizant of the loss of liberty, as well as the stigma attached to Gerald Galt's determination as a delinquent child as key factors in its opinion. Following the Supreme Court decision in Galt, the U.S. Court of Appeals for the 10th Circuit expanded its mandate of the right to counsel for a mentally retarded person. The court recognized the liberty of an individual is at stake, asserting that it matters not whether the proceedings be labeled civil or criminal, or whether the subject matter be mental instability or juvenile delinquency. It is the likelihood of involuntary incarceration, with sick commands observance of the constitutional safeguards of due process. The court required counsel in hearings regarding confinement in facilities for the mentally retarded, acknowledging the need for a guiding hand of legal counsel at every step of the proceedings. Several years later, the District Court for the Eastern District of Wisconsin announced the broad and encompassing directive of the procedural rights of persons with mental illness in Lessard vs. Schmidt. The court articulated the constitutional rights of those persons subject to involuntary confinement and treatment, spelling out the right to counsel, elements of adequate assistance of counsel, the significance of the adversarial nature of the role, and the importance of providing counsel adequate time to prepare and review all relevant material in the case. The effective assistance of counsel for a mentally ill person confronting involuntary confinement requires court guidance. The U.S. Supreme Court recognized in Strickland v. Washington that the right to counsel includes the right to effective assistance of counsel. The court explained that the Sixth Amendment right to counsel is the right to effective assistance of counsel, and the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. In India, sections 328 to 339 of the Code of Criminal Procedure, 1973 deals with special procedure to be followed in the case of accused being insane. Section 328 starts with the procedure to be followed by the magistrate if he found that the accused is insane during the proceedings before him. The section reads as follows. 1. When a magistrate holding an inquiry has reason to believe that the person against whom the inquiry is being held is of unsound mind and consequently incapable of making his defense, the magistrate shall inquire into the fact of such unsoundness of mind, and shall cause such person to be examined by the civil surgeon of the district or such other medical officer as the state government may direct, and thereupon shall examine such surgeon or other officer as a witness and shall reduce the examination to writing. 2. Pending such examination and inquiry, the magistrate may deal with such person in accordance with the provisions of section 330. 3. If such magistrate is of opinion that the person referred to in subsection 1 is of unsound mind and consequently incapable of making his defense, he shall record a finding to that effect and shall postpone further proceedings in the case. 1.4 Homeless Persons, Legal Aid. In Queensland there is Homeless Persons Legal Aid Centres for the following purpose. 1. Assisting hundreds of Queenslanders experiencing homelessness. 2. Providing millions worth of free legal services to some of Queensland's most vulnerable people, and 3. Contributing thousands of hours of pro bono legal work via casework, community legal, education and law reform activities for and on behalf of people experiencing homelessness. Given the complex range of pressures and issues confronting homeless people, including financial, social, psychological, medical, health issues and sometimes multiple legal issues, civil law problems often go unaddressed unless services are appropriately located and delivered. Accordingly, HPLC clinics are held at places already frequented by homeless people. Each law firm participating in the project provides a roster of volunteer lawyers who attend their nominated emergency accommodation or welfare agency and provide free advice to homeless people. Volunteers provide advice in most areas of law and may assist clients on an ongoing basis by undertaking research and/or casework. Volunteers may also refer matters to other firms, agencies or projects better suited to dealing with the client's particular needs. In addition to the clinic work, the HPLC seeks to identify gaps in the delivery of legal services to homeless people and examine relevant policy and law reform issues. All HPLC work is undertaken on a pro bono basis. Without the dedication of our volunteers and the generosity of our members' firms, the HPLC would not exist. Lawyers volunteering in the HPLC program participate in an ongoing continuing legal education program and receive training on a wide variety of topics including family law, consumer debt and bankruptcy, fines, guardianship and the public trustee, police powers and responsibilities, tenancy and other housing issues, welfare rights and other social security issues, homelessness, and indigenous sensitivity. CLEs are held once a month and are hosted by participating firms on a rotational basis. The host firm either arranges for in-house lawyers to give a presentation or may organize for external speakers from relevant organizations to present. In the past, training has been provided by organizations such as Legal Aid Queensland, the State Penalties Enforcement Registry, the Adult Guardian, Caxton Legal Centre, Tenants Union of Queensland, Welfare Rights Centre, the Department of Housing and the Aboriginal, and the facts and information brochure links at the right. Eligibility for assistance. People whose matters fall within the following legislation will be eligible for assistance from the Service Anti-Discrimination Act 1991, Child Protection Act 1999, Commission for Children and Young People and Child Guardian Act 2000, Education, General Provisions, Act 2006, Guardianship and Administration Act 2000 and Powers of Attorney Act 1998, Information Privacy Act 2009 and Right to Information Act 2009, Manufactured Homes, Residential Parks, Act 2003, Residential Tenancies and Rooming Accommodation Act 2008, Retirement Villages Act 1999. People appealing a QCAT decision, even if it does not relate to one of those pieces of legislation, will also be eligible for assistance. How much assistance is provided will be determined by a person's means and priority will be given to those who cannot afford private legal assistance. The service may refuse to provide assistance in some cases, such as those cases which lack legal merit or those which are so urgent the service cannot effectively provide assistance in time. A. Person who is a declared vexatious litigant or with whom the service has a conflict of interest will not be eligible for assistance. People eligible for assistance will be entitled to a 45-minute consultation with a solicitor. In some situations, further appointments can be made. The solicitor may provide 1. Legal advice, including advice about appealing a QCAT decision. 2. Assistance in drafting documents, including QCAT documents and correspondence. 3. Advice about other options for the resolution of a dispute, and 4. Advice about QCAT's processes. The service does not provide representation or act on a person's behalf. The service may refer a matter, if appropriate, for further advice, support, or representation. People seeking assistance from the service need to complete a client intake form and sign the services terms and conditions, available at the registry or below. Their matter will then be assessed and, if eligible, the person will be contacted to arrange a 45-minute appointment with a solicitor. The service, at its discretion, may provide further appointments. Appointments will be held on Tuesday, Wednesday and Thursday mornings either in person or by telephone. Initially, a maximum of 3 appointments per morning will be offered. This will increase as the service becomes established. If a person is not eligible for assistance, they will be notified of our reasons in writing. The service will not provide legal advice to drop-in clients. However, the service can provide general information, help people complete the client intake form and assist them to complete QCAT forms on a drop-in basis. In the landmark case Sheila Barse vs. State of Maharashtra, 1983, Supreme Court considered the right to legal aid to under trial and convicted prisoners. Court, after considering various problems with regard to the legal aid to under trial and convicted prisoners, pronounced the following directions. 1. To send a list of all under trial prisoners to the Legal Aid Committee of the district in which the jail is situate, giving particulars of the date of entry of the under trial prisoners in the jail and, to the extent possible, of the offences with which they are charged, and showing separately male prisoners and female prisoners. 2. To furnish to the concerned District Legal Aid Committee a list giving particulars of the persons arrested on suspicion under Section 41 of the CR.PC who have been in jail beyond a period of 15 days. 3. To provide facilities to the lawyers nominated by the concerned District Legal Aid Committee to enter the jail and to interview the prisoners who have expressed their desire to have their assistance. 4. To furnish to the lawyers nominated by the concerned District Legal Aid Committee whatever information is required by them in regard to the prisoners in jail. 5. To put up notices at prominent places in the jail that lawyers nominated by the concerned District Legal Aid Committee would be visiting the jail on particular days, and that any prisoner who desires to have their assistance can meet them and avail of their counseling services. And 6. To allow any prisoner who desires to meet the lawyers nominated by the concerned District Legal Aid Committee to interview and meet such lawyers regarding any matter for which he requires legal assistance, and such interview should be within sight but out of hearing of any jail official. In Sakdas vs. Union Territory of Arunachal Pradesh, A 1986 SC 991, the important question before the Supreme Court in connection with legal aid was that whether a criminal trial would be vitiated if the court which conducted the trial did not inform the accused about free legal aid and proceeds with the trial and resulted in conviction. The court strongly held if the appellant remained unrepresented by a lawyer and the trial ultimately resulted in his conviction would be a clear violation of the fundamental right of the appellant under Article 21, and the trial must accordingly be held to be vitiated on account of a fatal constitutional infirmity. The observation made by the court in this case is very significant. The court observed, now it is common knowledge that about 70% of the people living in rural areas are illiterate, and even more than that percentage of the people are not aware of the rights conferred upon them by law. Even literate people do not know what are their rights and entitlements under the law. It is this absence of legal awareness which is responsible for the deception, exploitation and deprivation of rights and benefits from which the poor suffer in this land. Their legal needs always stand to become crisis-oriented because their ignorance prevents them from anticipating legal troubles and approaching a lawyer for consultation and advice in time, and their poverty magnifies the impact of the legal troubles and difficulties when they come. Moreover, because of their ignorance and illiteracy, they cannot become self-reliant, they cannot even help themselves. The law ceases to be their protector because they do not know that they are entitled to the protection of the law, and they can avail of the legal service program for putting an end to their exploitation and winning their rights. The result is that poverty becomes with them a condition of total helplessness. This miserable condition in which the poor finds themselves can be alleviating to some extent by creating legal awareness amongst the poor. That is why it has always been recognized as one of the principal items of the program of the legal aid movement in the country to promote legal literacy. It would in these circumstances make a mockery of legal aid if it were to be left to a poor, ignorant and illiterate accused to ask for free legal services. Legal aid would become merely a paper promise, and it would fail of its purpose. A search through the legislations shows that in India there is lack of provisions dealing with legal aid to vulnerable groups in custody other than police and prisons. 1.5 Summary. 1. Right to legal assistance is not only for prisoners and suspects but also for persons in other custodies. 2. In some jurisdictions, the legal aid in other custodial institutions are insisting by legislations. 3. In India there is no legislation insisting legal aid to persons in other custodial institutions. Thank you for watching. We will see you in the next video with the next chapter.